Professor Gillian Triggs is the Dean of the Faculty of Law at Sydney University and an expert on international law. She advised the Humane Society International on its federal court case against a Japanese whaling company conducting hunts in Australia's whale sanctuary. And she joins me now in the studio. Professor Triggs, what will Australia's argument be to the International Court of Justice?
Well, the essential argument will be that Japan, like Australia, is a party to the International Convention on the Regulation of Whaling. And that, through that convention body, whaling has, since 1986, been effectively prohibited. There is now a moratorium, at least, on whaling of any kind, of any form of commercial whaling. So the essential argument by the Australian government is that the Japanese whaling is not permitted under that ban, and that the exception that Japan relies on, and that is scientific whaling, is in effect not genuinely scientific. That is the core of the argument. But other arguments rest on the other conventions, the Convention on the Trade of Endangered Species, in particular certain species of whale.
Now, I understand that this is not going to be a very quick process at The Hague. Can you explain a little bit about it?
Well, the court does give the parties quite a long time. The process has been Australia nearly a year ago submitted its application to the court. Both states are party to the court, so the jurisdiction shouldn't be a major problem. Australia then has had a while to produce the detail of its application, and that now will be submitted, I understand, in the next day or so, and Japan then has until March next year to present its side, and then the matter will go forward to the court, but it certainly will be a while.
So this case is really not going to have a material effect on Japanese whaling over the next couple of seasons, at least, you would think?
No, except that there is a possibility to apply for what's called an indication of preliminary measures. It's a very technical term, but what it's rather like is an injunction in domestic law, and you can stop the action, or the court can order that the action be stopped if there's any prejudice to a species, and that would certainly be possible. You could get action more quickly.
Is there any precedent for this type of case?
Oh, there are many precedents for indications of interim measures that the court is very